In Assam, citizenship determination relies on a legacy and linkage system which is formalized during the updation of the National Register of Citizens. Under this system, persons are supposed to establish if either they or their ancestors have been residing in the state of Assam pre 1971, 24th March 1971 to be exact, through documentary means. If they cannot themselves place their own names in the electoral rolls or in Assam before 24th March 1971, they are supposed to prove through another step, that of linkage, that they are directly related to their ancestors, either via documentary means or as is largely done through the NRC of 1951 or through electoral rolls predating 1971. However, this is an onerous historical as well as documentary requirement that falls upon persons who are appearing before the foreigners' tribunals, meaning that if I need to appear before a foreigners' tribunal, I need to obtain documents dating back to over 50 to 55 years and then prove that I am related to the persons who are either mentioned in the documents or that I myself have existed and my name exists in those documents as they are seen. Persons largely rely on electoral rolls of 1971 or 1966 or other documents such as Jamabandi, which are land records or school certificates or multiple other ways through which they would try to prove their existence in the state of Assam before 1971. It is worthwhile to note that while the documentary burdens are onerous, a further onerous condition is that a person only has the time to obtain these documents from the period from which they are served a notice by the foreigners' tribunal to the period in which they appear before the tribunal for the first time. This period is generally not more than 2 weeks. In 2 weeks, for a person to obtain documentation from local government offices, which dates back to 60 years, proves to be a huge task for most persons. A lot of people who receive these notices come from extremely marginalized communities, especially the Bengali community in Assam, the Bengali Hindus, Namshudra Hindus, as well as the Bengali Muslims, who have been residing in Assam over decades. Apart from the burdens of obtaining documentation, it also entails significant financial burdens. Obtaining a voter list from a government office is itself an onerous task, and getting it done quickly means that persons invariably have to pay bribes or have to pay people who are a part of the system to obtain the documents in a faster way. There is further also requirement under the Foreigners Tribunal's order that a case be heard as fast as possible and be done in a period of over 2 to 4 months, which means that members are also not willing to allow more time to litigants who appear before these tribunals to obtain these documents, which invariably means that because there is no time at hand, a lot of litigants who appear before tribunals do not have access to the best documentation that they can get to prove the legacy in Assam before 1971, which invariably affects their case. One of the things that has been documented over the years before the foreigners' tribunals is that a lot of members across multiple foreigners' tribunals in Assam continue to disregard oral evidence, which is a major cornerstone of evidentiary law. Under the Indian Evidence Act, oral evidence forms one of the 2 ways through which evidence can be adduced before a court. Since a person appearing before the tribunal has to predate their existence into Assam to 60 years back or 70 years back, as well as that of their ancestors, oral evidence is generally an effective way to prove their existence in the state pre-1971, either via relatives, either via family friends who would have resided in the same village, or the village headman or the Gaubura who would have resided in the village then. However, since the tribunals continually disregard such evidence, it becomes further difficult for persons to make their case before these tribunals. A lot of the times, even though litigants do adduce oral evidence, when oral evidence is not supplemented by documentary evidence, members tend to disregard their case, even though a clear case may be made out by depositions that are made inside the tribunal. A bunch of times when depositions are made inside the tribunal, they are not cross-questioned by the assistant government pleader, which means that the testimony is good in law. If the state cannot prove that the contents of the oral evidence were not valid, then the evidence has to be held as valid in law. However, that continues to be disregarded by the members of the tribunals, who do not even consider uncontested testimonies as vital to proving one's case before the tribunals. Through the course of the opinions of the foreigners' tribunals, there have been multiple times where minor issues or discrepancies, either within documents or evidence, have led to the opinion and conclusion that a person is a foreigner. For example, electoral rolls in Assam are transliterated by local area officers into different languages, which means that invariably an electoral roll which is written down in English and translated by a person in, say, Bengali, in Assamese, in Hindi, finds certain differences in terms of the way names are pronounced and written. For example, a Nawab becoming a Nawad in a Hindi electoral roll, or a Nawab in a Bengali electoral roll in the language, can become an issue before the tribunal, and the tribunal does not consider these minor discrepancies that come as a result of human error. There are also titles which are conferred upon people in the Bengali culture, or dark names that they use, which are pen names, which sometimes find their way onto official records. Hence, a woman who is initially a begum and becomes a khatun, or takes upon some other title post-marriage, will not be considered by the tribunal to be the same woman as who was on an electoral roll before that marriage. As a result of these minor discrepancies, a lot of the times persons are declared foreigners even though they have access to adequate documentation as well as adequate oral evidence, where families, brothers, sisters are coming before the tribunal to adduce evidence, as well as the local village headmaster, or the Gaubura as they're called. Another instance which definitely pervades a lot of the FT adjudication system is minor changes in the spelling of men who find different spellings on different documents. At a time when a land document would have been made in the 1960s, if their name was spelled in a particular manner, but on the electoral roll, there is a slight change in the way that person's name has been spelled, this becomes a cause for the Foreigners Tribunal to discard that evidence and not consider it entirely. All of this largely goes against the basic tenets of Indian evidence law, where minor discrepancies, as long as they can be corroborated with other evidence, or when evidence is read together as a whole, you can certainly make sense of a certain narrative or story as to the person's existence in the country, has to be considered. But time and again, the Foreigners Tribunal bleakly discards such documents, such evidence, such oral evidence, which leads to the declaration of persons as foreigners. So it would be worthwhile to even think about the fact that it is not that people don't have access to documents, which is why they're becoming foreigners. People have access to documents and are adequately submitting documents, but in spite of that, and in spite of the oral evidence presented, they're still being declared foreigners, which talks a lot more of the due process and procedural safeguards ingrained into the Foreigners Tribunal system, as opposed to the kind of evidence that people are bringing on record before the tribunals. Complemented with the lack of a government pleader in the FTs, as well as the member whose tenure and independence of their membership is not secured, it connotes a difficult situation for a litigant to prove their case before the tribunal, and invariably leads to decisions on extremely minor basis where a person gets declared a foreigner.